Perfect.
Thank you.
Thank you. Perfect. And then you can go to the next one if you want. So we just did our introductions. We're going to talk a little bit about what our organizations are and the role we play in all of this. I will talk about the history of the legislation, so you have context for how it came to be, and then and a little bit more about what it is. And then me and Carlos are going to kind of tag team what is the source of income discrimination exactly, and then Jocelyn's going to talk a little bit about what resources are available and what you can do if you're being discriminated against. And we also welcome, conversation. So if I think it's all right if you have a question to go ahead and raise your hand. I think we can talk about it at the moment. And then, but if it feels better to hold it, you can wait till the end and we can talk about it then as well. So you want to go to the next one, Mary? So Housing Action Illinois, if you haven't heard of us before, we're a housing advocacy organization and we mobilize housing providers and we work a lot with COCs and kind of across the continuum of housing providers that with a goal to increase affordable rental housing, expand home ownership opportunities, and effectively end homelessness. And we sort of raise voices in order to do advocacy at the state and federal level mostly for resources. You can go to the next one. And so there are different things that we do. I'm part of the policy advocacy team, and the policy advocacy team also does education organizing like I'm doing right now. But we also serve as an intermediary between HUD and housing counseling organizations as well. And you can go next one. All right, so I'm going to share a little bit about Hope Fair Housing Center and we can move on to the next slide. So as I introduce myself, my name is Jocelyn Rios. I oversee the Education Outreach Department at Hope Fair Housing Center. We can move to the next slide. A little bit about Hope. So as I mentioned, we are a nonprofit organization that specifically just focuses on fair housing discrimination. So if people are contacting us that they're experiencing alleged discrimination, that's where we kind of help and intervene. Our mission is just pretty simple. We want to create greater housing opportunities for all individuals here in Illinois. We want to ensure everyone has the chance to live in the place of their choosing, free from any form of illegal discrimination, which Carlos and Megan will talk about later on in the presentation. But just kind of keeping with what we do at Hope, we can move to the next slide, Mary. Our organization is kind of split up into two departments. So I'll talk a little bit about what I do. So I oversee our education and outreach department. So a lot of the work that I do is going out into the community and doing presentations such as this one. So it's not just specific to source of income, but really anything that's protected under federal, state, and local ordinance are things that we try to make sure people know their rights about. For housing providers, it's something we offer too, just something that they know what their obligations are under fair housing laws. The outreach portion of our department focuses on us being out in the community, so attending any events. If you are a community organization, we always love participating in events because it's a great way to share our resources, make sure people are aware of fair housing. I think it's something that kind of people aren't aware about that they have rights for. So we try to be just out in the community as much as possible with that in mind. And I did bring some resources today for you all. So feel free to grab some if you'd like. We can keep in the next slide still, sorry. The other part of our organization focuses on our enforcement department. So they are the first people, if someone is experiencing discrimination, that they talk to. We kind of have this intake process where people contact us. We can kind of determine whether or not it's discrimination. I'll talk more about our intake process later on, but we could do a couple of things, whether that's testing to determine if what they're experiencing is alleged discrimination, and also investigation work too. And then this last little component doesn't really necessarily fall into any department in particular, but I thought it was important to include, given that we're talking about a protection that Housing Action, Hope, Prairie State were really just, just pivotal in making sure that it passed in 2022 and was implemented in 2023. So we really tried to make sure we're on top of any policy change that would only benefit or enhance fair housing discrimination, or not fair housing discrimination, fair housing law, sorry. We can move on to the next slide.
Our office is located in Wheaton, so in DuPage County, but as you can see on the screen, we have a pretty wide service area. We are one of the largest fair housing organizations here in Illinois. We serve over 40 counties in the northern, north central parts and also in the southern parts of Illinois. There are some gray areas, as you can see on in that map there. Those fall out of our quote unquote service area, but if anyone were to contact us for any information or if they are experiencing discrimination, we would either put them in touch with the best contact, or if we happen to be the only contact, then we would kind of handle those matters in that sense. Then we're good to move. It's perfect. Sweet.
Hi again, I'm Carlos Soar from Perry State Legal Services. So just to let you know, I'm out of the West Chicago office. We have 11 offices serving 36 counties throughout northern and central Illinois. We pretty much handle every county except Cook County because they have their own resources. We do civil cases only, no criminal, no traffic. We're funded by the Legal Service Corporation, income assets restrictions. Some restrictions from callers without immigration document made, but many exceptions as well. So we will deal with clients who are immigrants if they are survivors of domestic violence or trafficking. And we have no financial requirements if it's the 60+ community, senior community, or veterans. So it doesn't make a difference what your income is. We will serve you for free. So some of the other things that we take on as far as our legal services, as far as public benefits, we fight for you a public benefit. If you get denied SSI, Social Security, disability, Medicaid, Medicare, SNAP, we don't get involved when you're applying. We get involved when they deny you. That's when you need an advocate for you. That's when we get involved. We do guardianships. We do wills. Now I tell people wills can be expensive. Sometimes $700 to $1,500. We do wills for you, licensed attorneys for free. We fight for housing, whether it's evictions or foreclosures. If you're dealing with a utility shut-off, we get involved with that. We also do sealing and expungement of records. We know sometimes that can hinder people for something being on their background for many years ago as far as getting housing, getting loans and things of that nature. So you go to the next one. So there's different lines you can call for specific reasons. Like if you're dealing with something domestic violence, there's a phone number you call. I have brochures and things as well. You get those numbers. If you was dealing homeowner issues as far as housing, there's a phone number you can call as well. Legal assistance for our senior community. And we do low income tax planning. Now, we don't do your taxes, but if they're trying to garnish your taxes or if there's something wrong with your taxes or the government take your money unjustifiably, you call us and that's when we get involved.
Okay. So now I'll get into the history of the legislation and how it came to pass. So this took decades to pass, this legislation. There was a coalition that was formed, decades before, but it was really revitalized during COVID when a lot more people were kind of seeing this highlighted, and there was a lot of vulnerability there. And so the coalition kind of came back together to pass this legislation because of that. So it was passed in May of 2022, became law in 2023. But before this law was passed, Illinois did not have protections against discrimination based off of legal sources of income, which includes SSDI, SSI, veterans benefits, child support, any, other kinds of non-wage income. You could be denied housing based off of your source of income. Next slide. The coalition was called Illinois Coalition for Fair Housing, and these are the organizations that kind of were a part of it. And Housing Action Illinois included Hope for Housing. I know Prairie State Legal Services played a role. So these are kind of a breadth of coalitions that kind of focus on different areas, but still had folks that they advocate for that were affected by this source of income discrimination. Next. So I think it's helpful. Yeah.
Is that coalition still together or is that disbanded?
I don't believe that there I don't think they're specifically working on anything at the moment. So I think it's sort of disbanded.
Okay.
Yeah. So I think it's helpful when we're talking about defining our terms to understand what source of income discrimination actually is. So it's helpful to understand what housing discrimination is, and it's when landlords or agents, lenders, housing providers, or really anyone that can get in the way of you attaining housing, impose different conditions on housing contracts because of a person's protected class status. And a protected class is it's a group of people who are legally protected from discrimination because they have a specific kind of trait. In this specific instance, that trait is their source of income. So the legal manner by which an individual supports himself or herself or his or her dependents is the exact definition. But we'll get into exactly what examples of source of income are a little bit later on. But just so you can kind of see, yeah. Oh, sure. Oh, thank you. But I like this slide because I think it helps lay out how different kinds of protected classes come to be protected against the different, or with the different levels of government. So federally, certain protected classes are protected, right? There's protections for race, color, religion, national origin, sex, familial status, and disability. And then the Illinois Human Rights Act, which is what was amended with this legislation, included source of income. And it also goes, as you can see, well far beyond the Federal Fair Housing Act. We also have Cook County and Chicago, which obviously doesn't apply here, but is another example of ways in which some of these classes can be added and to, protect residents. Next. Yeah.
If you can go back to that, is there any significant difference between how any of these came about, whether it's under the Chicago Fair, the Cook County? Is there any significant difference in how they can be enforced, or the seriousness?
Yeah, so for, I think it just depends like the avenue people decide to take. So if someone is experiencing discrimination, say, based on their disability, it kind of just depends the avenue. So if they wanted to file a complaint, they could either do it through the Department of Housing and Urban Development at the federal level or through the Illinois Department of Human Rights at the state level. So it kind of just depends the avenue people want to take. I'll talk a little bit about the administrative complaint process a little later on as I kind of go over our intake process. That tends to be a very lengthy process, as maybe some of you know or maybe don't know. And even if people decide to file a court case, you could do that at the federal or state level. So it really just depends. Like housing status is only protected under the Cook County Human Rights Ordinance. So that would be the only avenue that someone would have if they're experiencing discrimination based on their housing status, would be to file with the Cook County Commission of Human Rights. So it really just depends what protected class is being discriminated against, and then sort of the avenue someone wants to take in terms
that
of.
breaks down to the enforcement issue, who's going to enforcing it. So it doesn't break down to what maybe the significance is of a violation under the federal act versus a state or a Cook County act. Whereas one, you might be able to be, let's say, thrown in jail as an example for how many. The other one, you'd get a fine. So it would vary. Yeah. So I know from my understanding, the Federal Fair Housing Act has probably the most repercussions. If for a housing provider, for example, if they were to violate it once, it would be a certain amount of money. The second time would be an additional amount and then the third time would be even more. So it just does depend. And I know the Illinois Human Rights Act is probably not as intensive as the Federal Fair Housing Act, but still nonetheless, it's still just kind of important to kind of keep those things in mind.
What is a covered criminal history?
It's someone that has a conviction record. So if they have been convicted, but that's just for Cook County. It's under the Just Housing Amendment, but arrest record is protected under the Illinois Human Rights Act. So essentially if a housing provider had, if someone with an arrest record were applying for housing and, a housing provider sort of has this tenant screening where they ask for a criminal background check. And in that background check, it comes back up that someone was arrested. Maybe they weren't, maybe they were. They cannot consider arrest record as a reason to deny someone housing. So it's just kind of good to know what is protected under each level of.
If they have a felony, can you under?
Yeah, if someone is convicted of has a conviction record on their record. In outside of Cook County, there isn't any protection for those individuals, unfortunately.
under the Cook County Human Rights Ordinance, there's a just housing amendment where anything that is older than 3 years cannot be considered. I would say though, sometimes there are a lot of
Mitigating circumstances.
that, and then there's also a lot of the tenant screening processes that housing providers tend to use can often be inaccurate or just have misleading information. If someone just has an arrest record, sometimes it could come up as someone has a conviction record, and that is completely false. So I think it's important to kind of, if that were the case, to kind of make sure that you do an individualized assessment, where you're able to just kind of determine whether or not someone is going to, be a good tenant, and make sure that, if they have those instances come up, that you're making sure that everything that pops up on their background check is, credible, and they're able to provide you with the information that.
And if I can turn in, and sometimes that's why I think it's important to get an expungement or seal your record. If you're working, you're paying your taxes, you being a great citizen, but you do have some of your background that's, years ago, many years ago, because what we did when we was younger, we don't do now, of course. So that's when we can do expungement or seal, which are two different things. So when you do apply for those, or whether it's employment or applying for a housing, that doesn't come up in affection. So that's why we encourage to go to expungement clinics and the sealing your record clinic. So that won't be a factor in when you're trying to look for housing.
I believe the city of DeKalb also includes college students as a protected class.
Oh, awesome. Good to know. Oh.
Another column.
There's so many, and every local ordinance is different, right? So it's definitely good to kind of get an understanding for what your local ordinance might have. Like I know even in Champaign, Champaign's another one that had source of income already as a protected class. But now we have it at the state level as well. So it's always good to just kind of, wherever you might be, just kind of know what those ordinances are.
So I think we probably understand at this point, but I'll just run through, in case it's helpful to understand all the different kinds of sources of income. Of course, one of the major ways that we see this, and even to this day, which is why it's really important that we do these presentations, is discrimination based off of housing choice vouchers, and using subsidies from the federal government to pay rent, using that as a means of discriminating against people. And so that's an example that is protected right under this legislation. Homeless prevention programs, emergency rental assistance, of course, wages from employment, TANF, child support, retirement income, all different kinds of income, even if it's non-wage, are now protected.
Next question about the third bullet, emergency rental assistance. Emergency rental assistance is available from multiple sources in this community. So who is this referring to? Federal dollars? Like rapid rehousing?
Well, it's any of them that would be protected under this.
So township funds,
Yeah. it's all
landlords could
protected.
not deny it.
They shouldn't be denying it simply because they shouldn't be denying an individual simply because they're using emergency rental assistance. Like that shouldn't be the reason why they're denying something.
So if a landlord says they won't accept funds from the township, and maybe this is a sidebar conversation, do we have to ask them the reason why?
So I mean, I think when, and I'll talk about this later, one of the things that I hope that we try to sort of encourage clients and encourage individuals to do if they are experiencing source of income discrimination is to do this sort of like self-advocacy where they send a letter to the housing provider that, maybe denied them based on emergency rental assistance, or because they have a housing choice voucher, and state like, hey, this is protected under the law. I want you to reconsider my application. I think there's oftentimes just a misconception of what rental assistance looks like. And so I think it's important for clients to advocate on their behalf. But yeah, I would say if someone, let's say they receive funding from the township and they're being denied, then that's when you would, you could contact us and we can kind of help.
Well, I have a
address the
situation, I have a tenant right now who's receiving the assistance, but his assistance isn't as much as his certificate of payment. He was already a tenant, and so we're working through it. But if someone new came
Mhm.
and that rental assistance was not adequate to pay the whole rent.
Yeah.
Right, that would.
I would deny them based on the fact that they didn't have adequate income for the
Yes,
rent.
yeah, and so
But it
those are-
wouldn't be based on the fact that
Yes.
they're getting.
Yeah, so those are instances where, you know, if like, and even similar with the housing choice voucher, if it's not enough to meet the rent, then yes, those would be instances where, you know, as a housing provider, you'd be able to deny someone. But it shouldn't be simply because of the source of income they are trying to use. I think that's the biggest thing to kind of take away from this presentation regarding source of income is, you know, you're doing what you need to do, you're going through that same process as you would with any other client. You know, if they can't meet that rent, that's fine, but it shouldn't be the denial based on them being a voucher holder, them being using rental assistance or really any other type of assistance. And this is also not an exclusive list either. But yeah, that would be.
Will you address, if someone has a housing choice voucher, Section 8, if they're a program participant? And the landlord has, their income requirements that the tenant or potential tenant must earn 3 times the monthly rent? And how that should be addressed?
Okay.
Does that make sense? I know.
Minimum income policy, yeah, so the minimum income policy, in that instance would be applied to the rent, the portion that the tenant owes. So
Right,
the voucher, that has to be calculated in a different way, so I'll just kind of use an example. So say, you know, housing is listed at $2,000, the voucher that someone may have is $1,500. You would subtract the 15 from the 2,000 and the $500 is what the individual with that voucher owes. That's what they are responsible for. If a housing provider has a minimum income policy of 3 times the rent, the 3 times the rent is for that $500. So as long as that individual shows that they make $1,500, they would essentially qualify for that housing. So that's how the minimum income policy is applied. Under the Illinois Human Rights Act, the Illinois Department of Human Rights has an extensive FAQ that I included in this presentation. So definitely a great thing and resource to just kind of look at. There's a lot of guidance, things that tenants should know, things that housing providers should kind of just kind of keep in mind and just keep up to date with as you're kind of learning and kind of navigating how source of income applies.
In situations where people come to you and you're advocating for them and you see that discrimination has occurred, can you say it's more related to landlords not understanding the law? Like, that's a great example
Yeah.
of how someone could misapply it.
Right.
Do you feel like it's usually landlords not understanding the law, or do you feel like it's more often intentional discrimination?
There are instances where it honestly ends up being a little bit of both. And I think when I talk about some of the cases that Hope is working on in regards to source of income, it might like kind of make a little bit more sense because sometimes it is systemic where it's not just a one-time off instance, you know, where it's like consistently they are denying voucher holders and it doesn't matter who you are, what you look like, it's just because of your voucher, right? So there are instances where it's a one-off time where people are like, oh, I just miscalculated it. I didn't realize like this is how you had to calculate it. And that's times where we can, you know, contact them and be like, hey, you know, the calculation was wrong. They just want to be able to live here. Can you reapply the minimum income policy? And most often, you know, housing partners will be like, yep, I own up to it, move on. And then there are instances where it is systemic, where it happens more than once, where it ends up becoming a pattern as opposed to a one-time off instance. But I'll let Carlos talk about the prohibited acts because it might make a little bit, we might be able to tie some of those things.
Areas in the state where you feel like that is happening more than others, or you think it's just kind of consistent across?
I think, you know, the law has only been in play now for almost 3 years. So I think a lot of it is, you know, this learning curve of like, how does it apply? You know, this is a new protection. So I would say it's pretty wide across the board. My hope is that a lot of it is just the lack of knowledge, but you know, that's where organizations like us can kind of come into play, provide presentations like this and be like, hey, this is what the protection is, here's the guidance, things like that. So I think it's just kind of across the board. And even like Chicago and Cook County's had it for, I don't know, over 10, 12 years, this protection, and there are still instances where discrimination happens. So, you know, I can't say it's one or the other. Unfortunately, it is like a mix of both. But I'll let Carlos talk about the prohibited acts.
Prohibited acts. Okay, tenant acts, like something called a smoke gun. People may be able to identify this on their own. Direct evidence usually available. You go to the next slide, then I. And it's a discrimination statement advertised, sexual harassment, hostile environment, retaliation, interference, threat, steering. So for example, you might have some landlords who only want to well, I went to a place, he didn't want to rent to women. You know what I'm saying? And so when I went to go see him on the north side of Chicago, when I got out the car, he said, "Oh, okay, you're Lisa, not a woman," but you know, he didn't want to see African American either, but he was like, "I can at least deal with you because you're a man." He blatantly said that to me. So that's a prohibited act. But I go to the next slide so I can. So convert a different treatment, compare as user needed. Evidence to uncover, like the Fair Housing Testing Project, discriminate. So this is what we do, similar to what we call secret shopper. You familiar with that? So say, for example, we have someone go to a place and they deny them because of their race, or they deny them because of their age, or deny them because of their sexual orientation or their religion. So once you tell us as a law firm, I think I was discriminated against, what we do is we would send someone out there, it's like a secret shopper. We'll say, "Hey, we need you to go out there and apply," and then we'll see what we get back. So if we send someone out there and we feel they have the same treatment, and then we'll get in from a legal aspect to take them to court. Because some people, like she was saying, some people do it unintentionally because they don't know, and some people do it because they don't want to rent to certain people. So lying about the availability. For example, recently we had a client, she applied, she's a single mother. She applied and she had the income to make it, but he don't want to rent to single mother. His whole thing is just married couples. So he said, "Oh, that apartment is not available anymore. It's taken. I apologize." And so she rolled past 2 weeks later, it's still available. So we sent someone out there who wasn't a single mother, who was a couple, who was married. He said, "Oh, yes, it's available. Let's fill out the application." So then we had to take on that case, refusing to sell or rent. I have another example. There's a luxury apartment complex in Kane County. They didn't rent to my brother because he's African American. Well, let me explain something to you. He's a sheriff. When he came up there, they said, "Look, we got to do a background check." He had his uniform on with his sheriff. He said, "Are you serious?" He said, "I understand the procedure, but it took them 3 weeks." He said, "We're just waiting for your background to come back." He went up there the second week. He said, you can't be serious, are you?" He said, "I work for the sheriff department." "I know, but your background is important." He said 3 weeks. So they don't want to rent to him because of his race and so forth. So that was something.
They didn't say that to him.
No, they didn't verbally say it. They just
heard that from the delay. And
yeah, for the delay. It took them I think 2 months to respond. And sometimes they'll come up and they said you had a property that went into foreclosure. He said, "That was 20 years ago. So my credit is, I think his credit is like 780. He said, "What that have to do with, So he talked to his attorney. He said, "No, that's not right." So once we sent a few other people out there, that's the result we got. They don't want to rent to people of certain people of color. They did. It was only him and his daughter. So yeah, so we'll try to find out. See, some owners and some landlords won't blatantly say it, but some are so ignorant they would. They'll say, "I don't take vouchers. I don't take vouchers. I don't." And I don't want voucher people because they think certain voucher holders has a certain character. You understand? So they don't have work ethics, or they don't have, values and so forth. So they'll tell you, "We don't take vouchers." You can't say that. Some of them are just ignorant. You know what I'm saying? So it's okay. Also, hybrid or others don't mean intended and not require or related to disability related protection. So say for example, you go to a place and they say, "I will rent to you, but we don't have a rep." They can't do that. Then you got to build one. If you don't have a ramp, don't get me wrong, there's some certain things that's required for that. But they say, oh, we can't rent to you because we don't have a ramp. We can't accommodate, especially as a complex, we can't accommodate the people, who in wheelchairs. Well, the government will make you build one to accommodate them.
Reasonable accommodation.
There you go. Good culture things. So prohibit acts refuse to grant a reasonable accommodation, what we were just talking about. They can't do that. Advertise use all white models or only seniors without disabilities. They sometimes these owners do things that is amazing to me, and they refuse people and they'll come up with good excuses. It's just up to us to see some people. What happens is once they refuse housing for any reason, people don't feel like they can afford an attorney to fight for them. That's why it's important we come out and say, we'll fight for you. We'll fight for you and we'll do it for free. So I tip my hat to the attorneys for my law firm, because I think that the most important thing to them is to serve the people and to find out people who's not being just. And then we take them to court. And most of the time we win, 90%. You go to the next one.
Is there a difference, Carlos, between number 1 and 2?
Number 1 and 2. One.
They're not numbered, but.
Okay, no, I see what he's saying. Hold on.
Patricia has.
I have a question. Thank you. Hello, can you hear me?
Yes, I can. Patricia.
Okay, thank you. I have just a townhome that I rent out. When my kids were in college, I used it for them, and for a long time I've rented it. So this isn't particularly about me. I've had very good renters in there, very nice for a long time, and we managed to work things out when there's a rough patch or something. But I do have a friend who rents an apartment, and he gets what you're talking about, like he gets so much that the state or whomever pays, and then he pays the difference. Now, when his landlord would like to make more money on the rent, so I have no judgment about that, but my question is, can he refuse to renew the lease because he wants more money than what my friend can contribute and the government contributes? Does that make sense?
Yeah, that makes sense.
So it would depend if the landlord is specifically, like, let's say your friend has a housing choice voucher, they use some type of, they receive some type of rental subsidy. If that landlord or housing provider is specifically raising the rent to sort of, kind of push out anyone who has that rental subsidy or uses that housing choice voucher, that's where it could potentially become discriminatory. If they're, if that landlord is just raising the rent across the board, then that may not apply in the same way.
Or requesting a side payment.
Mhm.
So the housing authority pays X number of dollars, you pay your 30%, but you need to pay me a little bit more.
Yeah.
So you need to pay me.
Yes.
So if there's
Yeah,
like
that's
if they're like, and that's like differential treatment, so it's something that Carlos kind of like talked about and sort of alluded to, that, they're treating that person, if they're treating that person differently because they have other sources, they are using other sources of income, that are non-wage based, like the housing choice voucher program that we talked about, emergency rental assistance, really any of the ones that we listed, then yes, it would be potentially discriminatory. I would say, I can't really be the one to say like, oh yeah, it's discrimination. I would say we would, at least for Hope, we would just, need more information. So, they could contact Prairie State, they could contact Hope, and then we can kind of determine, if it is a matter of discrimination or not. So, your friend could definitely contact one of us.
I would have to say that as well. You think about fair market price. Hypothetically, if the rent is 1,000 and it's been 1,000 for a couple of years, and most of the properties around there, there's like 2 bedrooms, accommodation are the same. He's now raising it to 1,700. And then, that's when a lawyer get involved and see, is he actually trying to push you out? So I would definitely say, call Hope or Perry State so we can try to get involved.
Yeah.
Okay, yeah, I realize there's probably not a cut and dry answer, but it would be for him maybe to sit down with somebody and talk about what's going on in the history and everything. So you can at least see if, like, for example, if everything in the area, he pays 1,000 and or his is 1,000 and everything in the area, say, has gone up to 1,200, you know, maybe I don't know, maybe there's something that can be worked
Yeah,
out.
and we definitely
they'll-
don't have to like, you know, fully like flesh out the details now, but that would be like an instance
Right.
where, you know, they would contact Prairie State, they would contact Hope, and then we can kind of walk them through that, and it's very important. And again, I'll talk about this later, when we talk about just kind of what our intake process is, but it's very good to just kind of keep any documentation, so if it's anything that's said verbally to your friend, or if it's everything's done via email, definitely keep those emails, really just kind of keep that just a detail of what exactly is going on, because that'll definitely help one of our organizations, if your friend does decide to call us, sort of determine sort of the next action steps.
Sure,
Thank you.
okay, well, thank you.
Thank you.
And I wanted to address it, the young gentleman, you were saying is 1 and 3 the same thing? Okay, 1 and 2, refusing to grant reasonable accommodation, not allowing reasonable modification. Yeah, basically it is.
Well, would
Yes.
one be the landlord not?
Yeah, like you could go through the
agreeing to make
formal
accommodations?
requests and you
Number
leave it.
two, like if you wanted to make a modification in your unit,
Yeah, well, no, like for example, refusing to grant reasonable accommodation would be on the landlord, not allowing a reasonable modification would be still specifically on the landlord, if it has someone to do with a disability.
Okay.
You know what I'm saying, that has something to do with a disability. Yeah, so it'd be the same, similar to like when they say advertising. Like they're advertised, you have different complexes that advertise, everybody is a senior community, but they advertise in everything that's people are walking around fine. There's no walkers, there's no wheelchairs. So that's what they're saying. We're only, when you come there with a wheelchair, they say, oh, you seen our advertising? This community where, you know, we try to just, you know, walk around and enjoy. We don't have ramps, anything of that nature. And so they're trying to target a certain people as far as we want seniors, but we don't want to deal with seniors with disabilities.
And accommodations, just, I know we're not talking about disability, but accommodations are like anything that's policy related. So if there's like a no pets policy, but someone requires a assistance animal, like a service or emotional support, that would come into play. And then modifications are like physical changes. So if someone needs their door widened, so if they use a wheelchair, they'd be able to get through their unit, like those would be things. So they're kind of different, but they're also the same, just that complete refusal.
And you have places say they don't accept pets, but if I have an emotional support pet or a senior, then they have to.
Yeah.
They have to take that in consideration, so.
But you have to supply some evidence.
Oh, definitely.
Yeah, like a third party verification.
Yeah,
is usually-
documentation to show,
yeah.
you just I can't come in with a pit bull and say, it's my
Emotional
emotional,
support, yeah.
he helps me out.
You can't deny based on the breed. And you-
No, not the breed, but
Yep.
no, that doesn't count,
Right.
but I was giving an example.
Right.
I'm saying that with no evidence, that's not gonna fly. So, you know, the whole point, we fight for tenants, but we also we still want our tenants to do right. You know,
Right.
we're not like we're fighting for tenants. We want to educate our tenants to pay your rent, or, you know, to be honest when you're renting a property. So it's also to help the owners, you know, we want you to have good tenants. We want you to have paying tenants. So, yeah.
and what is disparate impact?
Disparate impact,
So this focuses more, so there's like direct discrimination, so, you know, just like how we were talking about, with vouchers, just a house provider saying like, we don't rent anyone that has Section 8 or uses any type of federal assistance.
Okay.
Just for impact is a little bit more, convoluted, where it focuses more on a policy, so if there's a policy in place, you know, it seems neutral, but it's really does have an impact on one protected group, of any of the ones that are listed on the screen. So I'll just kind of use arrest record in this case. So if they say, oh, no arrest, anyone with any arrest record will be automatically denied. Obviously, that would be a policy that, you know, seems neutral, but arrest record is protected. So that's kind of where disparate impact kind of comes into play. So it focuses more on a policy as opposed to just that thought or idea of just that direct discrimination.
How about the question? Are we not allowing reasonable modification? Who makes a determination and what's it based on reasonable?
Yeah,
You mentioned about a door widening.
yeah, so and there's specific wording
under, unfortunately, I wasn't prepared to talk about disability today. But there's specific guidance, under the Fair Housing Act that determines what is considered a reasonable modification. One thing to note is that modifications are at the cost of the tenant, which end up being very costly. Ramps are anything from like $10,000-$20,000. So there is guidance under the Federal Fair Housing Act that HUD has kind of pushed out on like what is considered reasonable. So I can definitely share that. I just don't have that in my sort of wealth of knowledge right now, but there are two things that are used to sort of determine if it's a reasonable modification. But I could definitely share that after this training.
So onto that reasonable modification, so you said it was on the tenant, so if you have to put a ramp in, it was $10,000, the tenant pays for it. And it changes your property, right, the way it is, and then the tenant moves out 2 years later, I assume they're can take their ramp and go home, right?
Yeah, so there's so that's where I would need to kind of look at that guidance again. Cause I wasn't prepared to talk about disability today, but there is guidance that says, if it's a burden. And I'm trying not to butcher it. So that's, I'm like, there is guidance that kind of shows you like, what are ways to determine if it's considered a reasonable modification, that I will definitely just kind of share with you all if you would like.
And there's a kind of a front door and a back door because of a fire escape, right, too, that you don't want somebody in a building that can't get out the back door if the front door's on fire.
Right.
I think too, so.
Yeah.
As an example, and let me just qualify, I used to work for the Housing Authority and I was the 504 coordinator, so this is in my wheelhouse. We had a request for a tenant to move into one of our properties in Hinckley, and the unit was on the second floor. And so they had requested the reasonable accommodation and the modification to install an elevator into the property.
That's not possible or burdensome.
It was beyond burdensome. So we found another way to work with the tenant and offered them a different property, which worked better for them. So.
Yeah, and oftentimes like properties, under the Fair Housing Act, there are, after a certain specific date, I believe it's March 31st, 1991, properties that are built after that time have to comply with the 7 requirements under the Federal Fair Housing Act. So any properties that are built before that, not that they shouldn't be complying, but like the example that I'm gonna just use right now, you can't just install an elevator, but you might be like, hey, I have a first floor unit that is maybe more easily accessible for you to use, providing other accommodations, don't just flat out refuse the modification request, but just try to kind of come up with other alternatives as well. And sometimes it might not work out, so just kind of keep those things in mind.
Okay, so I'll walk through some examples of discrimination. So we talked a little bit about prohibited acts. These are things that you cannot do. So you can't have a newspaper ad for your property that says no Section 8. That is not allowed anymore. If you call, you can't say we don't take Section 8. That would be discrimination. You have to have a job to rent here. That's not the case. You can't do that. Don't accept township rental assistance, like was just mentioned. Or any sort of blanket policy to refuse emergency rental assistance. And obviously, this is pretty straight with the definition. You can't treat renters differently based on their source of income. So, and then the landlord will not fill out regular paper, sign contract, or allow property inspection required by a subsidy program. Oh yeah, so the landlord has to go through the steps of like filling out the paperwork and doing what's administratively necessary to allow for the tenant to use a subsidy program.
Could I go back and ask Mary a question about that?
Sure.
This came up before, about the township rental assistance. Aren't those normally short-term, maybe a couple of months or 2 or 3? You don't go on and say, okay, we'll assist you for the next 2 years of your lease.
No, well, so our general assistance.
Continuation.
Right, our general assistance is a continuation, but like Sue said, chances are it's not gonna be the full rent. It's just going to be. But our emergency assistance, people can only receive that once in a 12-month period. So, but we do, we just recently had a landlord not choose or let us know that they weren't gonna accept our payment because they didn't wanna give us a W-9.
Oh.
So, and this was recently before I knew this, so, I certainly have learned
So
something.
you do go on for, let's say, years.
No, this would have been a one-time.
Well, that one, but you have other categories.
general assistance.
Yeah, well, ideally, it doesn't go on for years. We're helping those people. It's a bridge program, so we're helping those people get their social SSI or disability or until they can secure employment again. But
So you're saying the landlord then should not be able to take that into consideration, even though it's somewhat temporary and it may only last for 3 months or whatever.
right, but if a person's rent is $1,000 and we're only gonna provide 550, they can say no based on that. Correct?
Yeah, so I would say like with this specific instance, it really just depends on like the mitigating circumstances for that specific kind of like client or who we're talking about. If they're receiving emergency rental assistance, they may be receiving other sources of income as well. So I would just try cautiously, I don't know if you are a housing provider, I would just avoid just flat out saying we don't accept any type of rental assistance or any type of, any of these other sources of income that we listed on in the previous couple slides. I would just again kind of go through the screening process that you do, and then just kind of go from there. But I would really tread cautiously with just saying not to accept any type of rental assistance.
I was gonna interject, so I'm talking about my experience with some of our community partners, like Chapel Street Church, Catholic Charities and so forth. What they do when they do rental assistance, they say, we're gonna give you the first month rent plus a security deposit. But they won't give it to you unless you can show them what was the reason you fell behind. What's the reason, because they're getting in your business to help. I'm talking about as far as the tenant, do you have an income? So they won't, from my experience working with them, they won't give it to you if you have no job. You understand what I'm saying? So I can't help you out this one time and you back in the same situation. So if they say, hey, I just got a job, this is what I'm making, I'm gonna be back on my feet, I just need a startup. Okay, great. So they go over your expensive and so forth. This is Catholic Charities, some of the other organizations, our community partners. They say, okay, it look like you can make it. Let's do it. If you can't make it, they're not gonna do it. You know what I'm saying? It's not that they don't want to help you, but they want to help you to fail.
Right.
So they want you to have when we say discrimination in your source of income, you gotta have income.
Yeah.
So that's it.
And I think this is where like instances of like, this is a really new law, right? Like we're still trying to, and not just we like us, but the Illinois Department of Human Rights is still pushing out guidance on how exactly this all applies. And this is where instances like this where, we have questions like, how does this apply? Like, this is kind of still like muddy. So I do want to highlight that, this is still relatively new. Just as much as we're kind of learning how this applies, like, if you are a housing provider that's joining us today, like, you have questions as well, and we want to give you the best answer as possible, but sometimes we don't know the answer, but that's still, we're trying to get those answers, not only just for us, but for you all as well. So great questions. Just kind of wanted to preface that as well, as we kind of keep moving forward.
Yeah, keep going. We have another slide of examples.
You want this one?
Yes, that's, was that the second slide? Okay. Is there a next one? I think sorry.
This is the third one.
I'm sorry, thank you. So a landlord can't only discuss background checks for voucher holders, right? That's treating someone differently. Landlord charges voucher holders extra for the application, cannot do that. Landlord insists that a tenant buy extra insurance if she runs through a domestic violence agency, treating someone differently again. Landlord requires an SSA participant to prove that, and I can't read that.
Sorry, and I can't move that.
That's okay. You know what? We'll skip it for now. A landlord tells applicant that her credit score is too low, doesn't even run credit checks for people without child support income, right? So treat someone differently, ran a credit check and they don't do it for other people. And impose different terms, conditions, or privileges or services because of how the individual pays their rent. All those are protected as well. Yes.
If you have somebody that has a support animal, no matter what that animal might be.
Yeah.
Can the landlord ask for additional security deposit because there's gonna be an animal in there?
No. So with the reasonable accommodations, that's kind of where, you know, like if they have a pet, if they have a no pets policy, you can't apply an additional charge or fee, just because they're requesting an accommodation for that service animal. A lot of the times, you know, you can ask for that verification, you know, if they would get it from like a medical therapeutic professional, or organization that maybe works with them intensively to kind of show you like the reason that they need this assistance animal, is for, you know, for them to be able to enjoy it and live their home. But no, you cannot require an additional fee or an additional security deposit.
I want kind of going back to the assistance on the rent. So I have a case where, let's say the rent is $1,000. And when the person moved in on the housing voucher program, they were to pay 500. Housing voucher was gonna pay 500. And that complied with everybody's needs, right? And then it goes down, then the next 6 months it goes down, while the housing authority is gonna pay 700 and they're gonna pay 300. Then it comes around the next year and you're gonna raise the rent a little bit, you get a hard time from the tenant because you raised rent, then you get it back and they're gonna pay $33. And the housing program's gonna pay the rest of it, and it's kind of not what you signed up for originally, and you're a little nervous that they wouldn't cover that initially, and why are they later, and is that just get a little nervous on that when it's that.
Yeah, that's when I
scary, right?
Yeah, I would definitely, because again, none of us here issue vouchers, so we understand the programs very generally, but that's when I would just recommend for you, you know, reach out to the DeKalb Housing Authority and just kind of ask like, hey, like, what are, like, how do you determine this? Like,
My application I had, you know, a couple years ago was totally invalid at this
Yeah.
point, right? From
what do you,
stuff, and you don't make them go to you don't make them re-up an application every year, stuff like that, you just kind of, you want to extend the lease. Jen probably has some comments on it.
Oh, I have lots.
yeah, that's when I would say like definitely, I think the biggest resource for you would be to just reach out to the housing authority. They,
Chelsea. She's the manager of the program.
yeah, and they can help you kind of just have a better grasp and understanding of how the program works. You know, the housing authority goes through a vigorous, like
It's probably more intense than
Yes.
what a private landlord does.
yeah, for
And it's
clients,
big.
yeah. And many people are waiting on the voucher list for decades. So it's a very, very intensive process that they already go through. So the housing authority already determines like they are able to meet their portion of the rent.
Right.
So that's when I would say to just reach out to the housing authority. They can provide you with that information.
$33, I shouldn't be.
Well, that just means that tenant's life circumstances changed. They may have been waiting for Social Security to come through. If there was, or they retired, or their source of income has changed.
I think they changed jobs because they would take a COVID shot.
But, you know,
Yeah.
and, you know, quite honestly, bluntly, I'll say, really not my business.
Yeah.
The landlord's still gonna get paid. Magically.
They're not gonna decide also. They're not going to.
No.
Oh, no, they can't, they have a contract, unless the tenant has done something wrong, there's,
That's, yeah,
you know,
that disqualifies them from the program.
Right.
Yeah.
yeah, so.
Okay.
The money will still magically appear in your bank account by the 5th business day of the month.
Yes. Yeah. So definitely, like I said, just to get a better understanding of the program, just reach out to.
Yeah, Chelsea will go over it with you.
Next slide. All right, so this is me. So I will kind of just go over just things that we're seeing here in DeKalb, just some source of income stats that we have based on our intake process and what we've kind of seen. So since the implementation of the actual law, we have received a total of 203 source of income related intakes. These are just things that we are getting calls about. So from January 2023, August 2025. In DeKalb, we have received a total of 32 just fair housing intakes, not specific to source of income. Yeah, DeKalb County. 32 fair housing intakes. So it could be anything from source of income to disability to race, anything like that. Um,
When you say intakes, do you mean people are calling you with questions or they're calling requesting support?
so they're alleging discrimination.
They're alleging.
Yes,
Okay.
yeah, so they're saying, hey, this is what's happening to me. I live in DeKalb County. For the city of DeKalb, we've received 7 source of income related intakes, and then in DeKalb County, it has been 9. Again, Prairie State and Hope, kind of share similar service areas, so I'm not sure, if Prairie State has seen an influx more of source of income related. Again, it could also be because people don't know source of income is protected class. So again, these are just numbers that we have kind of seen in our intake line. Just some common denials based on source of income. The most relevant still continues to be housing choice voucher recipients. Emergency rental assistance is still that one, again, where the guidance is still unclear on how to handle that, but we are seeing more and more calls about that. And then the third one is that the benefits of temporary assistance for needy families. We're seeing some more, we're receiving more calls about source of income related potential discrimination based on individuals who receive temporary assistance for needy families.
Question about that.
Yeah.
So temporary assistance for needy families is not a large amount of money. So just because a person receives TANF, that's not necessarily the reason they're getting denied, because that proves that they're not bringing in any other income.
Yeah,
So they may not be able to pay rent.
So it just depends on the instance. So like if they're saying, oh, you don't meet the rent requirements, again, that is something that we stated with the housing choice voucher program, if they're not able to meet the rent, then that's a basis for denial. But we are just seeing a lot more housing providers saying we just don't accept temporary assistance for needy.
Gotcha.
Okay. So just that flat out denial because of their source of income.
Okay, thank you.
Yep. So I want to talk about a couple of cases that Hope is working on that are related to source of income, and just, one of the things that I mentioned earlier, the woman in the back had asked, is it just a one-off instance? There are instances where it is a one-time instance, but often it is a systemic sort of just basis for denial. So I'll talk about our MAC properties cases. A lot of these cases that I'm talking about are still open. So these are just things that we are able to share right now with our cases. But Hope and 4 Black women filed a class action lawsuit in federal court against MAC properties for systemic source of income discrimination and racial discrimination. So all of our plaintiffs were housing choice voucher holders, and they were essentially denied access to quality apartments in the Hyde Park area. So the discriminatory practices that were alleged, MAC properties refused tours and applications for newer amenity-rich units to these individuals and to our plaintiffs, even though it was within their voucher budget. They were steered to, more older, outdated units that they did not request. We can kind of think back to all those prohibited acts that Carlos mentioned early in the presentation. And so through these complaints that we received, Hope kind of intervened and decided to do some testing. And with that testing, they revealed a pattern. So essentially, voucher users were either falsely told that units were unavailable, they were steered to these, less amenity-rich properties, or just flat out ignored altogether. When we did our testing, we used testers who were non-voucher holders and non-voucher holders with identical budgets to those individuals who did have a voucher, and they were shown these new apartments and received follow-ups. So again, this wasn't just a one-time instance; it was a systemic pattern. So why we kind of brought this element of racial discrimination into it is because 89% of Chicago voucher holders are Black individuals. So income discrimination sort of reinforces this racial and economic segregation. Not only did we claim that it violated, this federal or the state protection, but also Cook County and Chicago fair housing laws, as well as federal, because of that race component that I mentioned here. So our investigation was really triggered because of repeated calls that we were receiving from voucher holders who were trying to apply in these properties. So Carlos mentioned the tester program. Hope also has one. Just know that they are trained fair housing testers. We're not just sending people out with no sense of what it is that they're doing. And so they are, an unbiased party. They are just determining and just sharing what it was that happened in that incident based on that test. So through that testing, it was confirmed that consistent discrimination pattern that I mentioned in the previous slide. So discrimination is, kind of worsening this housing crisis that we're seeing, especially in these more gentrified neighborhoods like Hyde Park. Fulton Grace. So another source of income related case that we are involved in has similar characteristics as our other case, but this one was filed in state court. So, it's a relative, like I said, it's a relatively new protection here that we have under the Illinois Human Rights Act. So Hope, alongside Northside Community Resources and 4 housing choice voucher holders, filed a lawsuit against Fulton Grace Realty in state court for source of income discrimination. So just some of the discriminatory practices that were alleged. Once plaintiffs would disclose their voucher use, Fulton Grace agents would just flat out stop communicating with them. They were just denying their applications or refusing to provide them altogether. They would use irrelevant income and credit criteria to reject applicants, or they would just delay the application process. So our investigation not only was Hope involved, but it included Northside Community Resources, Legal Aid Chicago, and Chicago Lawyers Committee. And again, similar to MAC properties, we found that there was a routine mistreatment. It wasn't just this one instance that occurred. So we found that it was a company-wide pattern of discrimination and not isolated incidents. So very similar to the last one, they were just, all of our plaintiffs were seeking, much safer, more opportunity-rich neighborhoods with amenities that were accessible to them and that would, benefit them, because under the Fair Housing Act, everyone should be able to really be able to utilize and enjoy their home. So one of our plaintiffs, she lived with her 10-year-old daughter in an unsafe, unhealthy apartment and included mold, mice, break-ins. So she was trying to go through the process of, moving. She was a voucher holder. She was pregnant with her second child. She found a suitable unit with Fulton Grace. She was really excited about it. But she never actually received any application for it, despite her repeated follow-ups with them. So unfortunately, she was forced to remain in this unsafe apartment. And she was pregnant at the time. So she does currently live there with her 10-year-old and now newborn. One of the things, like I said, our organizations don't issue the vouchers, but the voucher program really is designed to provide housing stability and really provide access to, more higher opportunity areas for individuals who are in the program. And the rent is guaranteed through government payments. I think it's one of probably the safest methods of getting the rent paid for is because it's coming directly from this agency that issues these payments. It's not coming from the tenant. Irrelevant credit and income policies are often used as an excuse to either avoid working with voucher holders or just, simply denying them. Still me.
Can I ask a question?
Yeah, what's up?
With the government shutdown, does that affect payments?
No, okay, no. So things like that, I know, like even with Social Security benefits, the payments will still be processed.
Okay.
It's just more like you probably won't be able to talk to, I know with Social Security, you won't be able to mainly get your questions answered if an issue were to pop up. Payments will still be good.
Yeah, the local housing authority, they're fine.
Yeah, perfect.
They're flush.
All right, so how we can help. So I think I talked a lot, and not just me, but Megan and Carlos, we kind of use like a landlord or housing provider that can be held liable, but there are other entities that can also be held liable for potential fair housing violations. So anything from property management companies, municipalities, newspaper media outlets, Carlos did mention, publicizing any type of discriminatory ads, or really any of the other agents that you see on the screen here. We can move on to the next slide. Just some things to know, and this is where I'll kind of talk about this administrative process. So there are statutes of limitations, and this is something that we share with clients who are experiencing discrimination. So if someone were to file a complaint, or say we wanted to file a lawsuit at the federal or state court level, we do have to adhere to these different statute of limitations depending on the agency or avenue we decide to go. So with the federal and state agencies, so the Department of Housing and Urban Development or IDHR, it's 1 year after the last incident occurs or ceases. And then with federal or state courts, it's 2 years. Yeah. All right, you can move on to the next slide, but this is where I'll kind of talk about our intake process, sort of how we operate at Hope if someone is experiencing discrimination. One of the biggest things that I always mention, when I started working at Hope almost 4 years ago, I had no idea what fair housing was. I didn't know we had any rights. So a lot of people probably don't know that they have these different protections at the different levels of our government. So one of the things I always encourage people to do, if you don't know if it's discrimination, it's sometimes very hard to identify. We always just recommend contacting us. So essentially kind of what our process looks like, if an individual is experiencing discrimination or they just don't know, we ask them to call us. They would be put in touch with our intake person. Essentially what our intake specialist does is they just ask them questions about what it is that they're experiencing. We have relevant forms that we need to kind of determine whether or not it is a fair housing matter. And we also serve the purpose of sort of sharing what it is that fair housing is and how they're protected under the law.
On the flip side, can property owners call you to, make sure that they're not doing something that is?
There are instances where we can provide some technical assistance. I know we are predominantly client heavy, but I will say, with presentations like this is where you can ask like, hey, can we have a presentation? Like I have a group of housing providers that just kind of want to like freshen up on their for housing knowledge. That's where I can kind of come in, and that's where we can kind of provide and support, or we can also provide you with just like the guidances that we sort of use when determining if something is a matter of fair housing discrimination as well. All right, so once an individual kind of goes through our intake process, we can readily, easily determine if it is a fair housing issue. There are instances where, someone might call us because they want support looking for housing. Unfortunately, that's not something that Hope does, but we can provide them with a referral to the most appropriate organization or entity to further assist them with their search. If it is a matter of fair housing, essentially that intake goes to our enforcement team where they kind of determine any next steps that need to occur. And what course of action that they want to take. So this is where we kind of talk about, again, about this idea of testing. There are other ways of gathering evidence that include non-testing investigation, whether that's witness interview, property research, things like that. Usually our process involves a little bit of both to determine whether or not someone who is alleging fair housing discrimination is actually potentially experiencing it. All right, so once we at Hope feel like, we have the evidence we need to determine, this is a matter of fair housing discrimination, there are a couple avenues that one can take to sort of kind of get a resolution out of it. So I would say the majority of the time we try to do informal resolutions. Prairie State has attorneys on staff, we do not. So with an informal resolution, the staff, the complainant and respondent are all kind of able to agree on terms of condition. Rather than enforcement action where, we kind of go through that complaint process where someone files a complaint with HUD or with IDHR, that can take a very, very long time. We still have matters pending from 2 years ago. So sometimes an informal resolution tends to be
the better course of action for most of our clients. And oftentimes too, they just want a place to live. They're just looking for housing. And so we want to make sure that their end goal is what we sort of get out of that resolution. And then I'll let Carlos talk. Nope, you're good.
Go to the next screen, I think. Yeah, this is just some of the resources that you can go to, some of the website or Facebook, Illinois Department of Human Rights guideline. This is what I say as a property owner. So there were some things I didn't know. So let me give you an example. I came up in a two-parent home. So when me and my brother started on their properties, I only wanted to rent, and I didn't know, this is my ignorance. I only wanted to rent to married couples. I didn't do boyfriend and girlfriend because I figured it can break up if you're married, you're kind of stuck for a while. So that's what, and I used to only try to rent to that. So when I got in trouble, what basically Fair Housing basically explains to me, you have several applicants. You denied them because this was a single mother. That's, you discriminated. But if you would have picked this married couple, that's just your choice. You wouldn't discriminate. But you specifically said you don't want to rent to her because she was a single mother. You don't want to rent to them because they was boyfriend and girlfriend for 6 months. You can't do that. You should have just chose the better advocate for you. So sometimes we just don't know. So I would say, so it's not just fighting for the tenants, but it's also to choose the right tenant and know how not to discriminate and know what your rights is as being a property owner as well. You know, what you should do, what you can't do, what you can do. So I think that's important as well. So
Did I understand that right, Carlos? Just don't decline anyone. Just say, well, you know, I'm gonna keep this open for another week and just see how this goes. I'm not declining. I do when I see who else is gonna jump into the.
no, well, I don't.
I guess I didn't interpret that right.
No, it's if you have many applicants, you can always choose from the bad applicant, but never refuse someone for discriminatory reasons, whether it's source of income of any of that. But if you have what you consider a better tenant, you know, then that's fine. But if someone know you denied them because of this, then you have a different situation on your hands. That's all.
Great, me again. I think this will probably wrap up everything, but this is something that I mentioned when I was talking about just this idea of having clients sort of self-advocate for themselves. You know, I kind of went through our intake process. Enforcement action is sometimes just a very lengthy process, so there are instances where we encourage applicants or even service providers to sort of help this sort of idea of self-advocacy for their clients. And so in partnership with the Illinois Coalition for Fair Housing, which when Megan mentioned all the different groups that were part of it, as a sort of proactive thing we created a source of income toolkit just to answer some other uncommon questions about source of income in this new protection, and just this guide that provides individuals who may be experiencing discrimination with different lenders. So we can move on to the next slide. This is what kind of it looks like. I did provide some of the handouts for source of income. I also have housing provider ones if you want those as well, just to kind of keep with you.
Can I say real quick, there's a website that is still up. Okay.
Yeah,
Got it. Okay.
Yeah, so it's linked on there, but I can provide it for you all, where it kind of has all this information there as well.
You can just go ahead and download that like onto your computer if you prefer.
Yeah, so yeah, we're good.
Okay.
We're good there. So in this sort of toolkit that we have, there are two different template letters. So there's one where it's just general source of income discrimination, and then one on that idea of that minimum income and how it's applied, things like that. We can move on to the next one. So essentially each letter has pretty similar components. So it would describe what the discriminatory act is. So kind of thinking back to what Carlos listed, you know, where was the housing provider making discriminatory statements? Were they just denying you based on your housing choice voucher, your source of income? And then following that, it would include information on the law. So a lot of this includes the guidance that the Illinois Department of Human Rights has under the Illinois Human Rights Act. And then kind of to close out that letter, it would include the ideal outcome. Again, a lot of the time people just are looking for housing. So essentially the client would determine what they want. So do they want their application reconsidered? Do they want, if they paid for a application fee, are they asking or requesting for that back? That would be the general sample letter. The next slide is the minimum income sample letter. So very similar instances, description of discriminatory act for housing guidance. So with this one, what's a little bit different is that the Illinois Department of Human Rights does state that the minimum income policy can only be applied to the tenant portion. So that's something that's explicitly stated for this letter. And then again, kind of wrapping up that letter with just asking for the ideal outcome. So just for those who are interested or maybe, in the future decide to use this letter, it's important to just be specific. So with the woman who asked the question on her friend's behalf, it's always important to just kind of keep any names, any sort of documentation of things that you are experiencing if you think it is potentially discriminatory. Give a reasonable response deadline. So at least 1 business week, sort of providing that in the letter when you're asking the housing provider when you would want a response from them back. We can move on to the next slide. Knowing your desired outcome. So as I mentioned, I think largely it's always the reconsideration for their application, refunding an application fee, things like that. Identifying the subject. So most of the times we encourage individuals who are experiencing discrimination to just fill this out on their behalf. But there are times where, as service providers or community organizations might fill this out on behalf of their client. So it's always important to address who this letter is coming from and who it's being sent to. All right, and then what if advocacy is not successful? If, it does not work out, which, there are instances where it doesn't happen, you could definitely reach out to Hope, or, we could seek other avenues to kind of address that. We can also pursue that housing complaint, kind of going through that process of filing with HUD or IDHR, or even Cook County, depending. Again, we're in DeKalb, so it's probably not relevant to DeKalb. And then victims of housing discrimination may also seek assistance of a private attorney or legal aid services like Prairie State if they wish to just file a lawsuit.
So on that middle one then, is Hope actually sort of an informal arm of those various governmental organizations to get this whole process going so that the tenant kind of knows, has a guidance as to, and in other words, the enforcement eventually comes about through those organizations?
Yeah, so if we decide to, if a client decides to file a complaint, the complaint process is a little difficult to understand on your own. So that's where we could kind of come in to sort of help them through that process. And we're sort of kind of like this, I don't want to say middleman, but kind of like this, the person that's kind of on track with like determining, kind of knowing like where the case is at. Like I mentioned earlier, we have cases that have been open for a year, 2 years. So we can kind of keep on track with that and provide the client with updates. So we're just more of that like assistance to help them file a complaint through those different avenues.
That's what I was gathering from this, but so Hope doesn't really get in. Let's say there are some penalties involved and that suit is whatever is successful, then Hope is, you contributed to that success, but you don't actually get the penalties or are the.
No, I think a lot of that with our lawsuits, it just kind of depends what the damages are.
But you're a 501c3 where you're not receiving money from payouts.
No.
Yeah, that's what you're asking.
No. So like we wouldn't get like the damages if someone is experiencing discrimination. With lawsuits, it really just kind of I don't know, it's very different. I kind of understand that world to be like, oh no. But yeah, so we're just more of like that assistance.
Funding independent.
Yes. So this is the guidance that I was talking about a lot. If you scan the QR code, you should be able to get to that website where it kind of just lists out all the different guidances for source of income under the Illinois Human Rights Act with the department.
I do have a question.
Yes.
So am I correct to understand that with our current administration, they're going to be reducing the number of housing vouchers? Is that correct?
That's all.
You're
Yeah, there'll be cuts, roughly 30% from what I'm hearing. There'll be cuts to the continuum of care, rest report, Curler Street.
I haven't heard of any cuts coming.
And then I know for the fair housing,
Maybe it's
like
too early.
for the fair housing like initiatives program, which like we receive funding through federal government, I know that there has also been cuts, but we've also been granted funding, but with the government shutdown, it's all
So
kind of chaotic right now.
Right. But my question is if someone's voucher is gonna be discontinued, is both the voucher holder and the landlord, does anyone know if they're gonna receive adequate notice that this is coming, so preparations?
We hope so.
Okay.
Yeah, I mean.
It's very unclear.
Okay.
It's all very murky right now. And it's stuff that we talk about the Northern Illinois
Yeah,
Homes
that's,
Coalition, yeah.
all right, that was mine.
Any other questions?
We do have evaluations for everyone. We would love a little bit of feedback on. Oh, okay.
Yeah, there might be some. The survey is also in the chat. So anybody who's attending virtually can access it there. You just have to, where the green button is, or where the chat is at the bottom.
Yeah, does that mean if it gets cut by 30%, does that mean 30% of the houses go away, or does that mean 30% of the money goes away and it just gets dispersed amongst the?
No, they wanted to go with the landlord.
What do you think of that? Could be two ways.
I believe, and this is just my personal opinion, that the current administration would eliminate the programs entirely. There's a current bill and.
They're trying to do move to work, right, for the
Yeah.
programs?
Mhm.
Trying to do what, sorry?
A sort of this like idea of move to work programs where.
Oh, yeah.
Okay, so we do have some questions online. Can you do student-only housing regardless if they have a voucher or not? If they have a voucher and are a student, great, but if they have a voucher and aren't a student, would the landlord be obligated to rent?
You can't discriminate based off of you can't just only do student only housing if it's private, correct? That's not, like a university could, right? Or is that more complicated than that?
Yeah, I would just tread lightly with saying like only certain. Like listing a property or your units as only for certain groups. Mainly cause like students aren't protected from fair housing, but then you could essentially say you're virtually discriminated against everyone who might be protected under those.
Incidents in Decatur University, there's students specifically for housing. So it's an apartment complex. So someone who came who wasn't a student applied for, they denied, they said, we only rent to students. For this particular university, it's right across the street. They couldn't do that because, like you said, they're only.
Yeah.
So even though the majority of the tenants are student because it's right across the street from the university, they still couldn't say only. That was the key word. I think that's important.
Is there a limit on the number of emotional support animal pets?
No, there's no limit. The biggest thing, and I think often the misconception is, you know, when individuals are requesting an accommodation, most of them already have like that valid, like third-party verification that's saying like, hey, I have a disability, I have an emotional support animal or an assistance animal, and they allow me to fully utilize and enjoy my home.
So every animal that they might have serve a purpose for their specific disability. So there is no limitations on how many, the number, I guess.
Each animal has to be fulfill a specific need.
Mhm.
So if, and as a landlord, you have that right to say,
Limit them, yeah.
what is your disability?
Yeah.
Or if they have a service animal, you can't ask them to have that animal demonstrate what
Yeah.
the behavior is.
Can you ask for the source of that letter?
Yeah, so most of the letters come from a therapeutic professional or a medical professional. So it's literally just a letter, like, you know, if you're a medical professional, like, hi, I've worked with so-and-so for this many years. They would never disclose that person's disability, but say like they need their assistance animal for, you know, this, and this.
Right.
And then they would sign
Does
it.
it have to be on agency letterhead?
So you can't get those online too.
Yeah, you can pay.
Yeah.
Pay $30 to get them.
Yeah, I was gonna interject from a legal point of
Legal
view.
point.
It's okay to verify.
Yes.
I can't, if you say, Mira is a client of mine, I can't tell you why she comes to see me. I can say that letter's from me, that's it. You see what I'm saying? So you, like you said, you get anything online,
Yeah.
you know, so it's important to you verify just that information that it actually came from them, so.
So what kind of verification, other than that letter, what kind of verification would somebody ask for?
Just that
A
letter.
separate letter from the physician or whoever it is that?
No, that like, so if I have a two dogs and the letter saying that this particular dog and this particular dog is my emotional support or whatever, I have the letter specifically saying that from that physician or that therapist. That's all.
Well, as you mentioned, you know, I would want to ask, oh, did you get this from a couple of 3 or 4 or 5 visits with this doctor to determine that you needed this animal? Or did you get it by sending $30 to this person online?
I would say most medical or therapeutic professionals are not gonna write a letter for someone they haven't worked with extensively for that reasonable accommodation request. Just like from what we've seen, because we do, you know, aside from source of income, disability is still one of the largest groups that gets discriminated against, especially when we're talking about reasonable accommodations. So I will say that no medical or therapeutic professional would risk the potential of just flat out just writing a random letter for
If they
someone they
got-
haven't worked extensively.
Plus, if they got some sense, they don't want to lose their license.
Exactly.
But if you got a letter from somebody that didn't seem to fit the criteria.
That's when you can verify, kind of like what Carlos said. Yeah.
And did I understand that if they want, like, if they say they need 2 or 3 different animals, you can get a separate letter for each?
Yeah, you should, and then most oftentimes, an individual with a disability already kind of has those letters in place, because they, you know, they kind of know the process, they know like, this is what I need, so they're often already prepared with that, because, you know, their assistance animals are essential for them being able to utilize their home.
And somewhat related, if it's not a emotional support, do you still have to allow the pet if they have a voucher?
It's not, if it's not an
It's just-
assistance
Right,
animal.
it's just, I have a dog, I wanna move in here.
No, if it's not an assistance animal, it doesn't matter if it's emotional support or service animal. And they have a voucher, and their policy is that they have
A no pet
policy that doesn't, yeah, it's kind of irrelevant to the voucher portion.
And just one more thing about emotional support, comfort animals for service animals, you cannot require or demand a pet deposit because the animal is not considered a pet.
Yep.
As a land.
Providing a service.
And see, I didn't know that because I used to say if you had a pet, I might even do cleanup. So I was charging $200. I didn't know. So it was my ignorance. I thought, okay, you have a pet, that's fine. I'm gonna
Okay,
have a deposit of $250, you know.
Derek, it seems like you're asking some pretty specific questions about housing with fraternity houses and that. Maybe, is there someone he could contact? One of your agencies?
Oh.
Or, cause he's asking it, do you have to let them live in a fraternity house that you rent units to, that's not run by the college? And
So that was the person that was asking,
Yeah.
service animals, yeah. And so the fake letters, I think we addressed that. He's saying, look up the issuing doctor's license on Illinois Department of Professional Regulation. So if you get those letters about service animals, And you can also ask for vet and vaccination records.
Yes. Additionally, if you have a tenant that does have the housing choice voucher section 8, if they have their documentation from an online source, where you just go in and you submit your information and you pay your $258, and you get your card saying that this is your emotional support or service animal. Based upon HUD regulation, you do not have to accept that. I can send you my presentation on reasonable accommodations.
Okay, we'll put it up there with this one on our resource page. Great. All right, that looks like that's the end of our questions online. So thank you so much. If you happy, or there's resources up here, and then if you wouldn't mind bringing in your feedback, we'd appreciate that. Thanks for coming today.
Thank you. Guys, thank you so much.
And then are we able to see these numbers, all the slides that were presented?
Mary's gonna put them up on the website.
But sort of.